Welcome to the Deep Dive. Today we're really digging into a tricky area of contract law, specifically consent, undue influence.
Right.
Our listener needs to understand that line. Where does acceptable persuasion, just making a good argument, end? And where does coercive influence, the kind the law steps in on, actually begin? It's a fuzzy line.
It really is. And the stakes are high. When you sign something important, like a contract, or, in the case we'll look at, giving up your parental rights, the law presumes you meant it. You acted freely.
So overcoming that presumption takes a lot.
It does. A high standard of proof. We're going to focus today on Methodist Mission Home of Texas, v. NAB. It's a key case because it helps us shift away from this kind of vague idea of someone's free will being destroyed.
Yeah, that sounds hard to prove.
Exactly. Instead, the case helps us focus on a more concrete legal standard: excessive persuasion.
Okay, excessive persuasion. Let's zero in on that. What's the basic legal hurdle if you want to set aside a signed agreement, say like a surrender of custody, because you think there was improper influence?
Well, the general rule, you sometimes hear it called the Harper Rule in adoption context, says consent is only revocable if you can prove serious misconduct. Things like fraud, mistake, misrepresentation, overreaching, and the like.
And undue influence fits in there.
It fits under overreaching. Now, traditionally, courts used language from older cases like Rothermel v. Duncan. They talked about needing proof that the person's free agency and will have been destroyed and subverted.
Right. That's the phrase, destruction of free will. It just sounds philosophical, doesn't it? How could a jury even measure that?
That was exactly the problem. It's too metaphysical, too abstract. How do you climb inside someone's head and see if their will was destroyed? The modern approach, thankfully, recognized this issue.
So they needed something more practical.
Yes, something based on observable actions. Undue influence isn't just about what's happening inside someone's mind. It's about the external behavior of the person doing the influencing.
Okay, so if destruction of will is out, what's the standard they landed on? What makes it measurable?
The standard really becomes, was the person subjected to excessive persuasion? And this is critical. The law recognizes that persuasion itself, even strong arguments, cajoling, entreaty, that's all generally okay.
Even if there's a relationship of trust?
Even then, to a point. The law only steps in when the way the persuasion happens, the intensity, how long it goes on, the tactics used, when the whole picture becomes excessive. It shifts the focus to the influencer's actions, not just the victim's internal state.
That feels much more concrete, something you could actually show evidence for. Okay, let's apply this. We need to walk through the Methodist Mission Home case using that full analytical framework. Let's analyze Methodist Mission Home of Texas, v. NAB. First, can you lay out the legally dispositive facts? What happened with NAB in the mission home?
Sure. NAB was an unwed mother. She was living at this licensed maternity home run by the adoption agency. While there, she received counseling from one of their employees, Mrs. Joanne Burns. Now, the key thing is, NAB initially planned to give up her child for adoption. But shortly after her son was born, she changed her mind. And that decision is what really set things in motion.
Right. So how did the agency react when she said she wanted to keep her baby?
Well, according to the court record, as soon as she announced her decision, Mrs. Burns started what the court called an intensive campaign. This was over a 5-day period right after the birth.
5 days. Wow. What did that involve?
Repeated, structured interviews. And remember, NAB was physically very weak. She testified she was only sleeping about 3 hours a night. She called the whole experience a nightmare.
That sounds incredibly stressful.
Extremely. She eventually said she signed the surrender papers just to make the harassment stop.
Okay, that definitely paints a picture of vulnerability and intense pressure. So what was the core legal issue the appellate court had to decide about her consent?
The precise legal question was, did the evidence support the jury's finding that her signing those papers was the result of undue influence by the home's agents? And specifically, did that influence meet the standard of excessive persuasion, making her consent voidable?
Got it. And what rule did the court use to figure out if the persuasion was, in fact, excessive? Can you state the rule and break down its elements based on how the court looked at the totality of the situation?
Yes. The court applied the standard of excessive persuasion. They didn't look at just one thing. They judged it based on the totality of the circumstances. And to do that, they examined evidence related to 5 specific factors, or elements.
Okay, what are they?
First, the vulnerability distress of the person being persuaded, so their emotional and physical state. Second, the confidential relationship dependency. Was there a relationship of trust or reliance?
Okay, hold on. Just those first two, vulnerability and dependency. It seems like the law is already trying to protect people who are in a tough spot, right?
Yeah.
Especially if the person pressuring them is supposed to be helping.
That's absolutely right. Those first two factors kind of set the stage. They establish you have a susceptible person and the influencer has some leverage. Then the court looks at the tactics. So the next elements were
What are the others?
third, the intensity duration of campaign. How hard and how long did they push? Fourth, the imbalance of discussion. Was it a fair discussion or basically a one-sided lecture? And fifth, the use of improper means. Did they use lies or false accusations?
It's a very clear framework.
Yeah.
It focuses on things you can actually point to, objective behaviors. Great, thank you. Now let's do the court's elemental analysis. We need to go step by step. Starting with the person under pressure. How did the court apply that first element? Vulnerability and distress.
They found this element was strongly present. The court found NAB's testimony about being weak, exhausted, feeling trapped. They found that very credible. They specifically noted that an unwed mother right after childbirth is considered emotionally distraught and peculiarly vulnerable.
So her situation itself made her vulnerable in the eyes of the law.
Yes, her physical and emotional state made her uniquely susceptible to the kind of pressure she experienced.
Understood. Now, what about the second element? Confidential relationship and dependency. How did that factor in?
Oh, it was huge. Mrs. Burns wasn't just some random person. She was officially NAB's counselor, someone she was told she could trust for guidance.
Okay, the trust position.
And beyond that, there was practical dependency. The mother was relying on the home for help, finding a job, finding housing after she left. This wasn't just advice. Her future stability felt like it was in their hands.
So that dependency gave the agency significant leverage.
Exactly. It amplified the pressure immensely.
Okay, so they had a vulnerable person dependent on them. That brings us to element 3, intensity and duration of the campaign. What made the 5-day effort an intensive campaign aimed at overcoming her will?
It wasn't just the length, the 5 days. It was the relentless focus. The moment she said, "I'm keeping my baby," this campaign kicked in, and its only goal, according to the court, was to convince her to give up the baby.
So it wasn't supportive counseling at all.
No, it wasn't about helping her explore her decision. It was persistent, targeted pressure specifically designed to get her to change her mind back, aligning with the home's own goal of securing adoptions.
Right. Element 4, then, the imbalance of discussion. Mrs. Burns testified she was just discussing the pros and cons. How did the court see it?
The court essentially called that a fiction. They found that what Mrs. Burns labeled pros and cons was, in reality, a repetitive one-sided argument, an endless recital only of the cons, all the reasons she shouldn't or couldn't keep her child.
So a monologue, not a dialogue.
Precisely. It was just wearing her down, repeating the negative points, which fit the home's policy of encouraging surrender.
Okay, so we have vulnerability, dependency, intense pressure, one-sided arguments.
Yeah.
Given all that, was element 5, use of improper means, like outright lies, even necessary for the court to find undue influence?
That's a great question. Maybe not strictly necessary given the weight of the other factors, but it certainly sealed the deal. It was like the smoking gun.
Yeah.
And yes, improper means were used.
What specifically?
Mrs. Burns flat out told the mother she had no legal right to keep her child, which was completely false, a major misrepresentation of her rights.
Wow.
And there's more. When NAB's parents tried to support her decision to keep the baby, Mrs. Burns apparently accused them, with no evidence, of having bad motives, of trying to put something over on their daughter.
So undermining her support system.
Exactly. It isolated her, turned her against her family, making her even more dependent on the home and Mrs. Burns.
Okay, so putting it all together. Vulnerability, dependency, the intense 5-day campaign, the one-sided arguments, and then adding direct falsehoods and undermining her family. After weighing all 5 factors, what was the court's final conclusion?
The court synthesized all these elements. They concluded that the cumulative effect, the totality of it all, was influence that constrained her to execute a consent which she would not otherwise have executed.
Meaning it wasn't really her choice anymore?
Correct. The agency didn't just persuade her. The court found their excessive persuasion tactics, used against someone so vulnerable and dependent, effectively forced her hand. So the jury's finding of undue influence stood.
That elemental breakdown is incredibly helpful. Now, to really solidify this difference between acceptable pressure and illegal coercion, let's try a hypothetical. Let's push the limits on intensity, element 3, and improper means, element 5.
Okay, let's do it.
Imagine someone who's recently injured, maybe bedridden, completely dependent on a live-in caretaker for everything, including their daily medication. Now, this caretaker starts a conversation, and it goes on for 6 hours straight, nonstop,
6 hours, okay.
demanding the injured person sell their house to the caretaker, way below market value. The caretaker repeats the same arguments every 15 minutes. And here's the kicker. The caretaker falsely tells the injured person, oh, look, the city is about to seize your house for unpaid property taxes, even though the taxes are perfectly up to date. You hear seize, your heart drops. Does that cross the line into excessive persuasion?
Oh, absolutely. That's a terrifying scenario, and legally, yes, it clearly crosses the line. You've got the vulnerability, the dependency. That's clear.
And the intensity.
The 6-hour nonstop marathon argument, that's textbook intensity duration. It's designed purely to exhaust resistance. But the definitive factor, the thing that makes it clearly excessive, is the use of improper means.
The lie about the taxes.
Exactly. That outright lie about the tax seizure aims straight at creating fear and panic. When you combine that level of sustained, intense pressure with a deliberate material falsehood designed to distress the person, you're way past acceptable argument. It's coercion based on manufactured fear.
Okay, that really clarifies the role of improper means and intensity. So let's bring this all together. For our listener maybe facing an exam question or trying to spot this issue in a real-world scenario, how can they synthesize these rules? Can you give us a step-by-step diagnostic checklist?
Definitely. We can boil this down into an actionable framework. If you're analyzing a situation for potential undue influence, here's a kind of checklist to run through.
Look for the vulnerable party. Is the person involved demonstrably distressed, emotionally unstable, physically weak, or heavily dependent on the influencer? There needs to be susceptibility.
Okay, step 1, vulnerability.
Second, identify the relationship. Is it a confidential relationship, like counselor-client, doctor-patient, or caretaker? Or a relationship involving significant dependency? This context matters a lot.
Step 2, relationship type.
Third, measure the persuasion. Was the effort to persuade sustained, intense, and overbearing? Was it designed to wear the person down, not just a single chat or debate? Think about the duration and frequency.
Step 3, intensity and duration.
Fourth, evaluate the content. This is crucial. Did the influencer rely on misrepresentations, false statements about facts, rights, consequences, or false accusations against the person or their support system? Lies are a huge red flag for excessive persuasion.
Step 4, check for lies or improper means.
And finally, fifth, conclusion. Look at all those factors together, the totality. Does the evidence suggest the influence actually constrained the person's decision? Was the final choice really the influencer's will imposed on the actor, rather than the actor's own free choice? Only if that cumulative picture points to coercion will you find excessive persuasion.
That's an excellent, clear checklist. Thank you. So the big takeaway today seems to be this sharp legal distinction between just being persuasive, which is fine, and excessive persuasion, the kind that exploits vulnerability, uses intense, relentless pressure, and, critically, often involves lies or misrepresentations, just like we saw broken down element by element in Methodist Mission Home.
Exactly. And it does leave us with a fascinating question to ponder, especially as you apply this outside the very emotionally charged context of adoption.
Oh.
Think about this. What if a big, sophisticated company used the exact same tactics, intense, hours-long, one-sided pressure, coupled with false claims about market conditions or legal threats, to get a CEO to sign a massive, maybe disadvantageous contract, even if that CEO was maybe just recovering from surgery, heavily medicated, perhaps temporarily vulnerable?
Would a court still find undue influence there without the same kind of emotional overlay as the maternity home case?
That's the question. How broadly does the concept of vulnerability stretch in different contexts? Can temporary physical or medical states count just as much as emotional distress when you're applying this excessive persuasion framework in, say, commercial law? Something definitely worth considering.